real estate of this room is a precious, limited resource. In general, it's difficult to get into courtrooms. It's particularly difficult in the family division to get into courtrooms, but it's difficult to get into courtrooms for anyone in any case.
The Second Judicial District Court of the State of Nevada is now in session. The Honorable Egan Walker presiding.
Thank you very much for that courtesy. Please be seated, folks. This is case number CB22-02069, generally entitled Tirzah Mathews versus Marilyn York, Incorporated et al. Appearances for the record, beginning with the plaintiff.
Yes, Your Honor. Thank you. Jason Guinasso here on behalf of the plaintiff, Tirzah Mathews.
Good afternoon.
Good afternoon, Your Honor. Mark Simons on behalf of Marilyn York and Ms. Marilyn York herself.
Good afternoon.
Afternoon, Your Honor. Frank Gilmore on behalf of defendant Ray York and his corporation, Law Profits, Inc.
Welcome all. Good afternoon. We're here by way of an order I set last week as I saw kind of a cascade of issues hit the docket. More particularly, my understanding of the outstanding pleadings thus far, not including the complaint, are as follows. The defendant, Marilyn York Incorporated and Ms. York, filed a motion to disqualify January 23rd, a motion for order shortening time on a motion for stay January 30th, motion to dismiss February 2nd. Plaintiff has filed a notice of intent to take default January 30th, in opposition to the stay, in opposition to the motion to disqualify February 3rd, and now a motion to strike February 6th. Counsel for Mr. Ray York has filed, and Law Profits has filed a joinder in the motion for stay and motion for disqualification and motion for an extension of time to file a responsive pleading that was filed February 1st. And so it would appear to me that the following is true. Last week, you all may know, you may not know, I had the privilege of conducting a murder trial in this department. We were luckily able to set the hearing for today because the trial concluded on Friday with a verdict. The week before, I was in an armed robbery trial. Tomorrow morning, I will start a civil trial, the subject matter of which is allegations of lewdness and sexual assault with a child. Next week is an open week. The week after that, I'll start another armed robbery trial. And so the context in which I saw this cascade of motions hit raised the concern in my mind that emergencies are being created rather than the normal process of a lawsuit. This case is a very important case, no doubt, to the parties involved and to me. Every case is an important case. This one raises some particularly serious issues and has serious subject matters. It was begun in a rather curious way. The complaint in this case is rather extraordinary in a notice pleading jurisdiction. I suppose we may discuss on a different day at a different time whether the language and details contained in the complaint were intended to give notice of claims as opposed to create a certain environment around this lawsuit. Irrespective, I set this hearing because I'm concerned that things have gone off the rails a bit, and I'd like to get them back on the rails. More particularly, I'm concerned with the following representation that's been made. Mr. Gilmore has made the representation that he was hired, correct me if I'm wrong, Mr. Gilmore, January 30-ish.
I was first approached by Mr. Simons to potentially come in and represent Mr. York on the Monday. I explained that I would have to meet with Mr. York and go over the particulars of the assignment and the engagement. Ultimately, after Mr. York and I were able to do that, we came to terms, and I was retained on the Tuesday, which was the same day that I prepared and filed my notice of appearance and the joinder to Mr. Simons' motion. That was the Tuesday before February 1st, which was when the answer was due pursuant to the extension that Mr. Guinasso had given to my client when he was unrepresented. That's the procedure of the events, Judge.
All right, so In a pleading lodged by Mr. Gilmore is the representation that he sought grace from the plaintiff, for lack of a better way to describe it, an extension to respond to the complaint in this case, which was, the representation is made, was denied without reason. And I know that there was a notice of intent to take default taken on about the same day. And I just wanted to bring all of you in to have a conversation about whether or not those narrow facts are true, and then a more broad conversation about how to manage the process of this case. Is it true, Mr. Guinasso, that no extension was granted?
Yes, Your Honor.
Why?
In my 20 years of practice, it's the first time I've ever not granted a professional courtesy of an extension. And the reason why in this case is it appeared to me that there was some gamesmanship on behalf of the defendants relative to just providing an answer and or some responsive plea to the complaint that was filed, up to and including the motion to disqualify me, which was joined by defendant Ray York. And with that context in mind, and with the representation that was made to me by Mr. York himself, that he had was retaining counsel and that he would be able to have his answer filed by February 1st, I took a particularly hard line in this case based on the exigent circumstances of the pleadings and papers that were filed in lead up to today's hearing.
But just to ask you all to consider the following. I'm a fan of observing during my privileged tenure as a judge in the family division and now in the general jurisdiction that the real estate of this room is a precious, limited resource. In general, it's difficult to get into courtrooms. It's particularly difficult in the family division to get into courtrooms, but it's difficult to get into courtrooms for anyone in any case. As I've noted, this case is an important case with serious claims and serious defenses to be raised and needs to be resolved on the merits. But no set of litigants, no set of parties is entitled to more than their share of the real estate of this room. And I fear you all are making decisions creating emergencies that are not emergencies. I appreciate your direct answer, Mr. Guinasso. I suppose it will be for a different judge on a different day in a different context to decide whether that was a wise decision or not. But I would suggest that filing a notice of intent to default in a case such as this, where the defendants are here, known, available, going to file responsive motions. A motion to dismiss is a responsive pleading, as an example. Is a waste of time.
Your Honor, I weighed that decision pretty heavily. Again, I have a reputation, I think, in practicing in this jurisdiction of being a reasonable litigant who tries to resolve cases, not make more problems in the cases. But in the context of this case, when a 36-page motion to disqualify me as counsel is filed, and at the same time a representation is made to me that an answer and or responsive pleading can't be filed timely, I was a bit incredulous about the representation in that context, and was concerned that the pleadings, and I put this in my email to Mr. Simon and to my other colleague, that I was concerned about the undue delay that was caused. I certainly want to get the case back on track. I think a lot of that will depend on how you decide the motion to disqualify, but given the circumstances, I felt like the hard line in this case was the appropriate tack to take, but it's not my general way of practicing law.
Well, again, it is important that you all take a step back and appreciate the need or not to create emergencies. I'm fond of quoting my friend Judge David Hardy, who's pointed out for the entire duration of my career with him, both as a litigator and now as a judge, that the courthouses are not emergency rooms. We are not designed to act in emergent, after-hours circumstances, except in the gravest of incidents, literally life and death. And nothing in this case represents life and death as yet, thank goodness, that I'm aware of. And you all need to keep that in mind. Today, my tone is intended to be conversational and measured. If this sort of stuff continues, it will not be conversational and measured for long. Because then it will be my obligation to rein you all in. And I would rather not do that. How long do you need to respond, Mr. Gilmore?
2 weeks would be satisfactory.
You may have 3 weeks
Thank you.
from today's date to respond with an answer, a motion to dismiss, whatever the appropriate responsive pleading may be. I don't intend to resolve any of the other outstanding motions. I do not believe they are right. Save and accept a motion for order shortening time, which is denied. This is not the kind of case where you all need to jam each other up or the court up unnecessarily. The issues raised are of particular importance to the plaintiff, to the defendant, and her family. Let us give honor to the importance of those issues by how we conduct ourselves. Anything else you'd like to raise?
No, Your Honor, thank you.
From my defense colleagues, first Mr. Simons.
Your Honor, I know you've read everything, and you are being conversational and measured, so I don't want to push this at all, except to say some of the emergencies that were created were in response to the refusal. I requested specifically the stay because of the importance and the significance of the motion to disqualify. That was refused. Then when I said, should we wait till after the hearing and then revisit what we do, that was denied. Instead, I received a notice of default, intent to take default, which then forced the emergency filing of the motion to dismiss. So I have been reactive, trying to calm the case and get us to where we need to be. And that's when, because of the motion to stay, I did the motion order shortening time, seeking to try to get a stay of the action so that we could move measuredly. So to the extent I created that emergency, that is why.
Well, I know there are reasons that each side has undertaken the decisions they have undertaken. Time will tell whether those reasons are good or not. I think the best use I can be to all of you, however, is to give you an idea of how I approach legal issues. I have litigated with all of you, some more than others, as an opponent on the same side and as a judge. I try to be a hey diddle diddle right up the middle kind of guy. And in this case, a default was about as likely to enter as a snowball in Hades. And so the need to react to the threat of a default was about as necessary as a snowball in Hades. That's just my worldview about it. I have denied the request for an order shortening time. There's a motion to stay that needs to now be perfected. Each of the motions that you all have filed has requested a hearing. They'll get a hearing. Assuming I don't find no purpose to be served by a hearing. I guess I would always reserve that right to say, look, I don't think this really warrants a hearing. But These things will be heard in due course. I beseech you all again to step out of the litigation role, which is very, very difficult to do. I don't pretend to have been very good at it myself, but to step out of the litigation role and also see the worldview of the kindly old judge in this case. I will give this case all of the time it needs. I assure you all. I may not get things right, but I don't think anybody will argue with the fact that I give cases the time they need. This case will get the time it needs in due course. I beseech you again not to create unnecessary emergencies for inadequate reasons. Mr. Gilmore.
I have nothing further other than would the court like some kind of an order from my office confirming the extension?
Yes, please.
I'll provide Mr. Guinasso a stipulation to that effect, and we'll get that entered.
Thank you. And I'll ask you, Mr. Guinasso, to do just a quick order denying the request for order shortening time on the motion to disqualify or motion for stay, as the case may be.
Yes, Your Honor, and based on your comments and the fact that a motion to dismiss was filed, I think it was late Thursday, I'll make sure that the notice that we filed is withdrawn as well.
I appreciate that.
Keep that case moving forward.
I
I
appreciate
don't know that we can agree to a stay, because I don't want the case to be delayed over what I think is a rogue motion. That is, the motion to disqualify is not a responsive pleading that should be heard right now. I agree with Your Honor that it's not right for adjudication at this time.
Well, I'm not going to rule on any of the other motions, as I've said. I would simply observe that a motion to disqualify counsel is a tactical tool that can have a legitimate basis or have no legitimate basis or somewhere in between in the spectrum. I don't know whether there's a basis or not. What I do know is that you all are strategizing with one another to gain advantage early in the litigation. And I would suggest that this case should be decided and marked by picking the right fights for the right reasons. Picking fights over a notice of intent to seek default in a justice system that has legion cases describing resolving issues on the merits is not a good reason. That's just my view about it. So, I would like, however, to set a case management conference with all of you, because really that's what this is about, in my mind, is managing how this litigation proceeds. I would suggest, Ms. Oates, that we find a date. We're going to call it a case management conference. It may actually be a date for evidentiary hearing as well, so like 60 to 90 minute window of time. I smile at Ms. Oates to all of you, because if you knew what the calendar looked like, you'd say, well, she should respond. It should be a Saturday morning at 10 a.m., which I won't do to all of you. Although Ms. York would tell you I've done it on more than one occasion in the past. I won't do that in this case.
How far out would you like to go?
I think probably 45 days, 45 to 60 days. I only say that because I know our calendar. I just think it'll be a miracle to find something even in 45 days.
Yes, I've been looking, Your Honor.
The good news is, I think the floodgates of COVID have broken. I don't know about for all of you in your practices, but this has been a remarkably busy January and February. I'm not sure I've had as busy a January and February as this has been. And my measure of it is, I just think the floodgates are breaking, which is a good thing, right? There's not, I don't want to say a backlog of cases because that gets misquoted, but there's just a lot of business that needs to be conducted. So we're all super busy.
In person,
Yes,
we have Tracy Petroselli on April 11th, so
a death penalty case.
So my suggestion would be to put it right after that, so 10:30 on April 11th is what I'm.
And that Petroselli hearing, that's a status
It's a
hearing.
status, yeah.
Okay, yeah. I think that's a good spot for it. And I'll give you all as notice in as much in advance of that hearing as I can about whether or not I want to have argument or as evidence. My hope is that we can perfect some of these motions, if not all of them, and then have whatever argument and evidence may be necessary at that hearing so that I can resolve them. In particular, of course, is the motion to disqualify, motion for stay, but I just don't know until the pleadings are perfected what I'm gonna want from all of you at those hearings, if anything. So we're gonna call it a case management hearing, but be prepared that it'll be dispositive so that it can keep the case moving by resolving some or all of these motions as appropriate.
April 11th at 10:30, Your Honor.
All right. I ask this cautiously, is there anything else we can constructively do today? Mr. Guinasso?
Yes, Your Honor, I just want, for clarification's sake, on the April 11th case management conference, that might be a date when we would earmark adjudication of the motions to dismiss if you deem appropriate, is that right?
Yes, anything that's perfected, meaning motion, opposition, reply, that seems logical in my mind, I'll try and give you all a heads up. For example, I'm not saying the motion to disqualify will require testimony or evidence, but if I thought it was, I'll try and give you a written order well in advance of the hearing so that you can bring whatever evidence I think may be relevant to resolve that issue as an example. But I'll try to resolve everything if it's all submitted by then so that we can keep things moving in all of your words. Anything else, Mr. Simons?
No, Your Honor, thank you.
So it is my privilege to preside in this case. I look forward to working through these issues with all of you. They are difficult, thorny, and important issues. I beg and beseech all of you to help me keep the goal in mind of doing honor to really the participants and to the citizens we serve by how we conduct ourselves in this case.
Your Honor, can I ask you one question? You have I think this might be for Alicia, but you have a hold for Miami site visit that Alicia put in. Are you involved in that?
Yes.
Do you want me to roll it a week?
Let's take an aside because you all deserve it. You may know, you may not know, the American Academy of Pediatrics, the American Medical Association, the American Psychiatric Association, the American Psychological Association, and others have all observed that there's a mental health crisis in the United States right now. That mental health crisis is deep in our community. And the chief judge, somehow I made her angry, has appointed me as the point person to engage in judicial leadership toward resolving mental health issues in the community. Talk about a big problem. Turns out that Miami is a model site for how judicial leadership has resolved mental health issues in a community. So there's a whole group of stakeholders who are going to go to Miami. So it needs to go to the next week.
Okay, and during that week, we have that Meyer trial, but I believe her counsel has withdrawn, and we're going to have a motion hearing on that next week or the week after. Are you safe? You think we're safe setting it there?
I do,
Okay.
I do.
Counsel, let's do it on, are you available the 17th, April 17th in the afternoon, say at 1:30?
You're not.
I'm not.
Okay, that's fine, we'll go with Halloween. Gonna have to go. Your Honor, how about, this looks like a much better week, the 3rd, which would be May 3rd in the afternoon at 1:30.
May 3rd, 1:30. I see affirmative nods around the room.
May 3rd at 1:30.
Thank you for noticing that conflict. I apologize for the conflict. Again, it is my privilege to serve with all of you. Please take good care of yourselves. In addition to everything else, COVID is rampant in the community, so please take good care. Good day to you all.
All rise.